Unprecedented, historic, long overdue, a political witch hunt. There is no shortage of hyperbole being used to describe the New York prosecutors' decision to file criminal charges against former President Donald Trump. It's the first criminal indictment of a former U.S. president in history. The Manhattan D.A.'s office spent the last few years investigating whether Trump violated campaign finance laws in connection to hush money paid to porn star Stormy Daniels before the 2016 presidential election. And now, following a grand jury indictment, the question is, what is next for former President Donald Trump? He will likely need to go before the court and enter a plea, since that's how the legal system is supposed to work. A spokesperson for the DA's office said prosecutors contacted Trump's attorney to coordinate the former president's surrender for arraignment. It's expected Mr. Trump will surrender voluntarily on Tuesday. The exact charges won't be known until the indictment is unsealed, but it's expected at least one charge will be falsification of business records, which carries a sentence of up to 4 years in state prison if convicted. For more now on how Mr. Trump might choose to fight these charges, we welcome New York-based election and campaign finance lawyer Jerry Goldfeder. Mr. Feder, thank you so much for your time.
It's good to be with you.
I want to jump off right off the bat here. When you first heard the news come down that a former president had been indicted, what were some of your initial thoughts, and what sort of challenges does a case like this present for both prosecutors and the defense?
Well, we expected this to happen, but nevertheless, because it is unique, it's a little sad to have a president or a former president criminally indicted. Now, we don't know what the indictment says at this point, so we don't know exactly what he's charged with. But given the fact that District Attorney Bragg is a very smart, diligent attorney, I'm certain that the office has looked very carefully to make certain that the charges are valid and that they stand an excellent chance of proving beyond a reasonable doubt that the former president has committed the crimes that they will be charging.
All right, so based on Trump's previous legal dealings, it's likely to assume he's going to try to delay these proceedings in some way. Do you have any insight on some levers that his legal team might try to pull to delay this process in any way? Can they reach out to Congress and ask for a helping hand? What do you think?
No, they can't reach out to Congress. Congress has no jurisdiction. In fact, the Republican leadership in Congress at this point is trying to interfere with the district attorney, the Manhattan district attorney's prosecution, but that will not be successful. Trump, just like any other defendant, might very well look at the prospect of moving to dismiss the indictment on the grounds that the evidence given to the grand jury is not sufficient to warrant this indictment. That's par for the course. That's within their rights as a defendant to do that. They may even move to change venue, arguing that a Manhattan jury can't be fair because the overwhelming vote in Manhattan was against Trump. I don't know that they'll succeed in either one of those circumstances, but it remains to be seen. This matter has been assigned to a no-nonsense judge, and I imagine that this judge will try to move matters along expeditiously and will follow the law to a T. So the defense has all sorts of procedural opportunities to try to delay the matter, even to dismiss the matter. And I can't predict whether they will succeed simply because we don't know what the charges are yet.
You bet. You bet. I want to follow up on something that you mentioned there about a change of venue. We know that Manhattan is Biden country. The president received, 85% of the vote there in 2020. Do you think it's a fair legal argument to argue for a change of venue for the former president?
Well, I think it's a non-frivolous argument, but I think that it probably won't succeed. New York is a blue state. There are pockets within the state that have voted Republican. So there could be a county where the vote was 50-50, if you will. But the defense, as well as the prosecution, will have an opportunity to interview every prospective juror to ascertain whether or not they will be fair and objective. The defense will have that full opportunity, just as the prosecution will. And so I think that at the end of the day, whether it's in Manhattan or wherever it might land, I think we will wind up with 12 jurors who are objective and fair, will listen to the evidence, apply the law, and make their decision.
All right. Some people might have been surprised that the case was gotten this far because of New York's statute of limitations. It's 5 years on most felonies, but it's obviously been more than 5 years since the alleged crimes took place. Can you explain to us why this case doesn't exactly fit the statute of limitations and why it's not DOA based on that 5-year limit?
Well, it's actually pretty simple. He's been out of the state, and that tolls the statute of limitation, meaning it extends the time by which a prosecutor can bring a case. And in addition to that, because of COVID, there was an executive order that also told the statute of limitations. So believe me, the district attorney has looked at this issue, and if they thought that the statute of limitations has run and they couldn't bring the case, they wouldn't. They believe that they are well within the time period, and therefore they're proceeding.
Absolutely. A lot of the evidence in this case seems to center around Michael Cohen. He was the one who made the alleged hush money payments on the part of former president, allegedly. So since Cohen was a lawyer, can the Trump legal team make an argument or make the case that Mr. Trump believed Michael Cohen was carrying out these payments in a legal manner because he was a lawyer?
Well, they can't make that argument. They have to submit evidence to demonstrate that. And how would they do that? They can question Cohen on the witness stand. They can even put Donald Trump on the witness stand himself to try to refute what Cohen says. But it's not just Cohen. There's other evidence, and that will come out. We've seen some of that evidence before in the Cohen case, but I think we will see much more of it. It's not a question of lawyers making arguments. It's a question of evidence in the courtroom and what the jury believes. They will try to impeach Cohen. Whether they succeed or not remains to be seen. They will try to undermine the various documentary evidence that will be presented by the prosecution. And it falls to the defense to try to muck up the works so that the prosecution can't prove beyond a reasonable doubt to the jury that these crimes have been committed and he should be convicted. So all in all, we'll have to see what happens in court in terms of the evidence, the testimony, and the documents, and what the jury believes.
Certainly a lot of things for us to wait and see as far as the indictment goes, and then possibly any future dealings with that. Jerry Goldfeder, an election and campaign finance lawyer with Strzok & Levin in New York. Thank you so much for joining us today. Appreciate your time.
My pleasure.
What sets Straight Arrow News apart from the other guys? Well, for one, we're on a mission to serve you, not an agenda. So for factual, trustworthy reporting, head to straightarrownews.com.